Well, Henshaw here again, Constitutional Crisis Channel. This is kind of a quasi-current events type of thing, although the case itself was decided in the 2016 term of the Supreme Court. But a very interesting case called Utah versus Strieff, Strieff. It's recent enough that it's not in the hardbound books yet, I don't think. I've seen a tentative citation for this. It's in volume 579, but I can't give you right now anything more than that. When I can, I'll put it down below, and we'll have it for you later. But it's a case where one of these damn search and seizure cases, and this is why I do not use the Fourth, Fifth, and Sixth Amendments, with the exception of the Bill of Particulars. I don't use them. It's a piece of crap. I mean, the Bill of Rights do not apply to the states, and I've said this, so often that you should damn well know what's coming next. Barron v. Baltimore, 32 U.S. 243. Chief Justice John Marshall said in 1828, Bill of Rights doesn't apply to the states. Case hasn't been reversed. Case closed. But this case involved with Strieff. This is Strieff fellow that was involved here. Got convicted when he walked out of a house. The cop had been sitting around there for several hours watching the house on the basis of presumed criminal activity with drug sales and so forth. And Strieff walks out, and the cop approached him and asked him for identification, which he should not have given him and was under no obligation to do. But he did, and the cop ran it and found out he had some damn old traffic warrant, outstanding, and arrested him on the warrant, searched him, and found methamphetamine on him, and he was convicted because of being obsessed with methamphetamine, and apparently for sale too. Well, the Utah Supreme Court unanimously reversed the conviction, unanimously, with summary opinion. So Utah appeals to the Supreme Court, and they reversed the Utah Supreme Court. I mean, unbelievable. And the troubling thing for me about this is that it was a 5-3 decision. It might have been 6-3. I don't know whether Scalia was still on the court when the case was heard, but he had passed away by the time it was decided, so of course he couldn't vote. So it ended up 5-3. But the real problem for me, as I said personally, is that among the five was Stephen Briarpatch, and he's normally a liberal, and sees that side of the court. And if he would have stayed with his liberal, members of the court there, Lena Kaganovich and Ruth Bader Ginsburg and Sotomayor, the case would have come out 4-4. The result of which would have been that the Utah Supreme Court would have been affirmed, and the conviction would have been reversed. What's troubling for me here is I think that Breyer engaged in what's called vote trading on the Supreme Court, and this is a practice I think they should never have engaged in to start with, and should stop for this. I mean, you can see what the thinking on the court is. Okay, we can put the case over and re-argue it when we get a justice on the court, and as we both know, that took close to a year to do that, with some political maneuvering that went on while Obama was still in the White House, and then of course Trump appoints Neil Gorsuch, which is far better than what would have happened otherwise. I have some difficulties with some of those things, but a video for another day. But that said, they could have put the case over, or they could have just let it drop, and maybe should have let this one drop. Because with the arguments that were made, I'm almost embarrassed to be in agreement with Sotomayor and Ginsburg on this, because that's not the side of the court that I would normally expect to support. Although this is also true in another case, we'll do a video on another day, called Odah, Odah versus United States. And that too, I was in agreement with them when they were in the majority in the case that arose out of Guantanamo Bay, Gitmo. But like I say, case for another day. So this isn't the first time I've been on the same side, but let's just say it's very unusual. So with this vote switching crap, and with the dissent of Sotomayor, you read this, and she's saying in effect that the court has done away with the Fourth Amendment. And she cited in her opinion the fact that in California alone, there's close to 3 million outstanding warrants, whether they're for traffic things, whether they're for being a felony fugitive no bail warrant, like what South Carolina did to yours truly here. 3 million warrants. And a damn cop can arrest you once they find out who you are for anything like that, and it could be an old warrant. It could go back, who knows, 8 or 10 years even. I don't know what the limit would be on such a thing. It's an area I'm working on research-wise. I'll get back to you about that part. But in effect, there's no search and seizure, and the rule pretty clearly up to that point had been just the opposite. And they should have gone with that and stayed with it. Because, I mean, and this is the problem I have with the Fourth, Fifth, and Sixth Amendments. What it comes down to is what they mean is anything that 5 justices on the court at any one time say they mean. And this, for me, goes back to an infamous quote, as far as I'm concerned, in a decision they decided much earlier, called Wolf versus Colorado, 338 U.S. 25, page 29, where they said, talking about the Due Process Clause of the 14th War Amendment, yeah, look for the citation here, they said that this clause secures, extracts from the states for the lowliest and most outcast all that's considered implicit in the concept of ordered liberty. What the hell is that? I mean, that's an oxymoron. I mean, wow. I'm sure Berger would understand that, but I don't. We don't know what it is. But 5 justices say at any one time, we can change the rules, it doesn't matter. That's not the way the system is set up here. We're supposed to have protections from the government, and in this day and age, they are very few and far between. And only when the government thinks that it has to make it look good, as far as I'm personally concerned. But this is a big deal case for the reasons I've cited here, that, my gosh. But it's why you don't even bother with search and seizure. I won't even raise that. In California, we have a special motion to suppress, I think it's Penal Code 138.5, whatever. Don't even bother with it, piece of crap. You're not going to have any luck there unless it's really, really bad, like this Merced case I've been talking about. Maybe. But other than that, I wouldn't bother with that. I would make a motion to quash service of process, which I'm doing now, and those of you that get my document packets are going to see that that's now in there. And I think that can be effective in a variety of circumstances, although I will not do it personally in my cases. And the reason for that is that I know most of you out there don't have anywhere near the background that I do. And I'm going to adhere to the same hard line I did exactly in South Carolina for 7 months, and I faced them down and I walked out of there. And I'm going to continue to do that because that gives us both sides, and we have our cake and eat it too. If things work with these motions and you win your cases, fine, let me know that. I'll be very happy to hear it. But I'm going to toe the hard line until we get decisions on this, because if we can beat them that way, that may even be better. But it's just hard if you don't have the background that I do with 4 decades and can't walk in there and just stop them dead like I did in Columbia, South Carolina. You just can't do that. I get that. So that's one of the reasons I've made this change in the documents I'm putting out there. Now, we'll see how that part goes. Anyway, the Strieff case, take a look at it, read it. In fact, if anybody requests, I'll send you at least a highlighted copy of it, if not a copy that I've had occasion to do at least some minimal annotations on. I'll be happy to do that. You can get a look at the case and see that it says exactly what I say that it says, and read the annotations and read what it really means if you can read between the lines. That's what it is I think I do as well as anyone. I get the nuances there that most people simply miss. And if I can bring that to your attention and let you see what's really going on, you get much better, and you're all of a sudden going to be far ahead of the district attorney too, and they won't know what to do with you either. Thank you.